Dear colleagues, dear friends, I am very happy to welcome you at our project Modern Arbitration Live that is supported by Legal Forum Academy and Russian Arbitration Center. Within this project we talk to the leading Russian and foreign lawyers on the most interesting and acute topics in the sphere of dispute resolution. Today we are very happy to welcome very special and interesting guest from Hong Kong, Joe Liu. Thank you, Joe, for coming.
Thank you.
Welcome to Moscow. Joe is the Deputy Secretary-General at the Hong Kong International Arbitration Center, HKIAC. And today we'll talk about HKIAC, about Hong Kong, and also about the new arbitration rules that were issued by HKIAC and that came into force rather recently. It's called 2018 Administered Arbitration Rules, and it's a very important landmark for the HKIAC in their history as arbitration institution. So first of all, congratulations with this great work being completed. So first of all, Joe, please tell us a little bit about yourself, what you do at HKIAC. So what was your professional way to come to HKIAC? Please.
Thank you, Adrian. As Adrian just mentioned, I'm the Deputy Secretary-General of the HKIAC. I have worked at the center for 5 years, and at the center I have 3 key areas of responsibility. The first is to oversee arbitration and mediation proceedings conducted under the HKIAC auspices. And the second area is to develop HKIAC's new rules and procedures. For example, the 2018 and the 2013 versions of the HKIAC Administered Arbitration Rules. The third area is to promote HKIAC's dispute resolution services around the world. Prior to joining the HKIAC, I was a registered foreign lawyer in ANO Allen & Overy's Hong Kong office as part of their global arbitration group. I also spent some time at the Singapore International Arbitration Center as their assistant counsel. And I did multiple internships, including one at the Permanent Court of Arbitration in The Hague. Before I started my career, I obtained an LLM degree at the London School of Economics in London, and another LLM at the New York University in the US. And prior to that, I studied at the Wuhan University in Mainland China, and I obtained my LLB degree there.
Okay, that sounds very exciting, and it seems like you know a lot about arbitration, not only in Asia-Pacific region, but worldwide. So I think that's very precious knowledge and experience for HKIAC. So please tell a little bit more about HKIAC in general, about its structure, about people behind HKIAC who worked at HKIAC, and also it's interesting in which jurisdictions HKIAC is now present.
Sure. So HKIAC is an international dispute resolution services provider. It was established in 1985 as a non-profit organization. It was established as a company limited by guarantee under Hong Kong law. The current structure of the HKIAC is this. So the highest authority, the governing body within the HKIAC is called the Council. It currently includes 25 members, and they are mostly lawyers, arbitrators, in-house counsel, judges, and also non-legal professionals. And there are also several standing committees within the HKIAC that were created to implement the policies approved by the Council, and also to exercise certain functions or powers on behalf of the Council. The Secretariat is the permanent operational body at HKIAC. We currently have 28 members, including lawyers who are qualified in both common law and civil law jurisdictions of 9 different nationalities, and we speak a total of 10 languages. And HKIAC currently has 3 offices. The main office is Hong Kong. We also have an office in Seoul, Korea, and another office in Shanghai, China.
Okay, so I think it's very good development for the 34 almost years of development. And I have also a set of questions about Hong Kong. So as I understand, Hong Kong is a special administrative region. I think that it's very interesting for Russian users and for Russian audience to know actually why Hong Kong SAR is different from the mainland China, which courts are authorized have jurisdictions to supervise the arbitration in Hong Kong. And also it's very sensitive, interesting question, what will happen actually when the agreement between Hong Kong SAR that determines its special status will expire, the agreement with the mainland China. So can you please clarify these interesting issues?
So Hong Kong as a special administrative region of China enjoys a high degree of autonomy, except in the area of self-defense and foreign affairs. And Hong Kong maintains its legal system that is different and separate from that in mainland China. And Hong Kong is a common law jurisdiction, and its legal system is based on the English law legal system, and mainland China's legal system is not. And Hong Kong's arbitration system is also different from the arbitration system in mainland China. The arbitration legislation in Hong Kong is called the Hong Kong Arbitration Ordinance, which is based on the 2006 version of the Untitled Model Law. In China, their arbitration legislation is the Chinese Arbitration Act, which is not based on the Untitled Model Law. It was enacted in 1995. The arbitration practice in Hong Kong and mainland China are also very different. I would say the arbitration practice in Hong Kong is more in line with the international arbitration practice, and mainland China takes a different approach in areas, for example, interim measures and also which authority can decide jurisdictional issues. And in terms of the courts that supervise arbitration proceedings in Hong Kong is the Hong Kong Court of First Instance. That court deals with all arbitration matters in the first instance. We also have an arbitration specialist judge. Her name is Justice Mimi Chen. She is well known to many arbitration professionals around the world, and she's known for her pro-arbitration decisions. So she deals with all arbitration-related applications filed under the Hong Kong Arbitration Ordinance. Now, in relation to the question of when the agreement between mainland China and Hong Kong will expire. Now, I think when you say the agreement, I assume that you mean the basic law of Hong Kong, which is the supreme law. It's like the mini constitution of Hong Kong. And in the basic law, there's actually no provision that provides for automatic expiration of the legal system and arbitration system in Hong Kong. So, and I have also not seen any sign of change of the legal system and the arbitration system in Hong Kong in the future. So, so there's no really like a deadline in the arrangement between Hong Kong and China that provides that the legal system and arbitration system in Hong Kong will expire at a certain point.
Okay, so that's good to hear that actually this system of like it's called one country, two systems, and so the legal system will keep moving on, yes, and keep existing, and that this is a myth that it will some just day evaporize somewhere. So that's really good to hear for the Russian users who choose also Hong Kong as a seat of arbitration. Okay, so reverting back to the 2018 HKIAC rules. Can you please tell more about how they were drafted, actually? So, because it's interesting also for me, as a representative of Russian institution who also drafted its own rules. So it's interesting to know actually the backstage of this process.
Yeah. So the process started in August 2017, when the HKIAC established a committee called the Rules Revision Committee to consider any amendments to the then current HKIAC administrative arbitration rules. And I was part of that committee. In August, the committee published a consultation paper setting out several amendments they proposed to make to the HKIAC administrative arbitration rules. And then we commenced a public consultation process for 2 months, and we circulated that consultation paper to members of the legal community in Hong Kong and outside of Hong Kong, and also posted a copy on our website. And during that process, many practitioners, arbitrators, in-house counsel, funders, representatives of government, and other interest groups provided submissions and comments on our proposed amendments or any additional comments they consider appropriate to be made. So we took them into account, and we produced a further draft and circulate that again to the public. And then we convened 2 public working group sessions at HKIAC, where we use a case scenario to discuss the application of some of the key provisions of the draft new HKIAC rules. And those working group sessions were proven to be quite successful and useful also for the institution to get a better feedback on how actually some of the provisions can be applied on a case scenario rather than just discussing in the abstract. So we had 2 sessions, and then we collected some further feedback, and then we incorporated them into a near final draft. And then we published that on the website. The draft was eventually approved by the HKIAC Council, and the rules came into force on 1st November 2018.
Okay, well done. So it was a really good collective work involving a wide range of professionals in the sphere of arbitration. It's really impressive. So can you please tell more about the main features of these new rules? What are your favorite features? Maybe there were some features that were not included into the rules, but you would like them to be, but in the course of these collective work discussions, the majority said, well, we don't need it at this stage.
We maintain some of the signature sort of a feature of the HKIAC rules in the new rules and introduce some new ones. The sort of the existing features that we maintain include, for example, the ability of the party to choose how to pay the arbitrators. So they can choose to pay the arbitrators based on hourly rates or the amount of dispute. And if they fail to agree within the time limit, then the hourly rate option will apply. We have also maintained the very popular expedited procedure in the HKIAC rules, which we introduced as early as 2008. In terms of the new features that we introduced, we have further expanded the scope of our multi-party, multi-contract provisions, which now include 4 mechanisms, such as the joinder of additional parties, consolidation of multiple arbitrations, and the commencement of a single arbitration on the multiple contracts, as well as a new mechanism called concurrent proceedings, which allow a party to request a tribunal to conduct multiple proceedings on a concurrent or sequential basis if the same tribunal is constituting all the arbitrations and there is a common question of law or fact. We have also introduced a new early determination procedure that is designed to deal with points of law or fact that are manifestly without merit or outside the jurisdiction of the tribunal. Or even if the points of law are assumed to be correct, no award could be rendered in favor of the party that alleged the points of law or fact. Those points of law or fact will be decided by the tribunal. And there is a 2-stage process for that. Once an application is submitted, the tribunal has 30 days to decide whether or not to proceed. And if the tribunal decides to proceed, the tribunal will have 60 days to make a final decision on the merits of the point of law or fact. We have also enhanced our emergency arbitrator procedure. Now we allow a party to seek the appointment of an emergency arbitrator even before they commence an arbitration. We have an overall fee cap on how much the emergency arbitrator can charge, which is in the amount of approximately $25,000 US. Our EA procedure also provides express test for an emergency arbitrator to apply when deciding whether or not to grant an emergency arbitrator relief. Another key change is that we now have a default time limit for a tribunal to issue its award under the HKIAC rules, which is 3 months from the time when the tribunal declares that the proceedings are closed. The tribunal also has to indicate to the parties when the award will be forthcoming. So these provisions are intended to provide more certainty to the parties as to when they can expect the final decisions. Finally, we have also introduced a number of provisions to reflect recent developments in international arbitration. One is third-party funding. We now have express provisions to deal with confidentiality, disclosure, and the cost of third-party funding, which are broadly in line with the third-party funding amendments to the Hong Kong Arbitration Ordinance. We also have provisions that encourage parties and the tribunal to consider the use of technology in arbitration. For example, we have a new provision that recognizes an option for a party to deliver documents through online document repository system.
Okay, so it's interesting about the time limits for issuance of the award. Do you have any sanctions for the arbitrators, like some other institutions have, if they don't comply with it?
Yeah, so we currently don't have any hard sanctions like what ICC has introduced, but there are consequences if a tribunal does not comply with the time limit under the HKIAC rules. For example, we monitor or keep a close eyes on the performance of any arbitrator. So we do collect information about whether or not they are able to deliver their decisions in a timely manner. So that is something that we will take into account. And also, I think for parties as well, and if they know that the tribunal in the case fails to comply with the time limit in the HKIAC rules, and I think that would also affect the parties' willingness to appoint the same tribunal again in the future cases.
Yeah, I agree. I think that the reputation is the main factor that shall encourage them to comply with these time limits, and that's also what we do. For example, at Russian Arbitration Center, that we collect feedback from the councils, for the case administrators, and we also just when the case is when the award is rendered, so we collect this feedback and we also report it to the board, and we will consider it in the future appointments. But generally speaking, it looks like the amendments that you named, and it looks like you are pretty much satisfied with the new rules.
Yeah, I'm very happy with it.
Yeah, that's great. So they address the concerns about efficiency, time and cost efficiency, and is also a kind of response to arbitrations becoming more and more complex. So I think all this multiple arbitrations, this issue with the hourly rates, I think it's effective answer to these questions and to the changes in the landscape of arbitration that we see worldwide. For sure, other institutions are also trying to find these responses. Can you please tell more about what actually distinguishes HKIAC from other arbitral institutions?
I think some of the features that I just mentioned distinguish HKIAC from many other arbitral institutions, the way how we pay arbitrators, the breadth of our multi-party, multi-contract provisions, and also our record of enforcement in mainland China. HKIAC awards traditionally enjoyed a very strong track record of enforcement in mainland China. Since the 1999 arrangement on mutual enforcement of arbitral awards between Hong Kong and China has been put into place, there have only been 3 HKIAC awards that were not enforced by the Chinese courts. And that is one of the key reasons why foreign parties prefer to choose HKIAC in their contracts with mainland Chinese parties. And I think another factor is the HKIAC's willingness to innovate, to listen to feedback, to find ways to improve its systems, and its willingness to experiment new things, and also to introduce new practice and new initiatives in areas that other institutions are not ready to make that first step yet. So we have been seen as the first mover in many areas of international arbitration practice. I think that is also another important factor that distinguishes HKIAC from many other arbitral institutions.
So HKIAC is innovative, and it's a good option for Russian parties, for Russian users, when they have some relationships, business relationships with the parties from Asia-Pacific region and specifically from China.
Yeah.
I will sum it up like this. Okay, so as I understand, the new rules were also the result of collecting some feedback from your users. So how do you identify the issues in international arbitration? So how you collect feedback and how you react and address such kind of issues?
Yeah, so there are several ways, and we monitor our proceedings very closely. So during those proceedings, and sometimes we'll be able to identify whether there is any issue or area of improvement raised by parties or up to tribunals. So we also have an evaluation system that can be used by parties and arbitrators at the end of the arbitration process to give feedback to the HKIAC in relation to the performance of the arbitrator and the performance of their co-arbitrators, and also the quality of HKIAC's case management services. So that is one source of information that we can use to identify any area for improvement. We also monitor trends in international arbitration, and we do extensive research about what's happening outside of Hong Kong, what other jurisdictions are doing to improve their arbitration practice, what other arbitral institutions are doing to improve their offerings. So we will also consider those developments to see whether or not that is something that we think that users of HKIAC arbitration can also benefit from. So we will collect information from all these sources and then consider ways to improve our rules structure and the framework and the services.
Okay, thank you. Another question is what HKIAC has done, and I'm sure is doing, in order to shape and impact the international arbitration practice in the whole region of Asia-Pacific, which is very, as we know, dynamic in the sphere of arbitration, alternative dispute resolution, mediation. So please share your experience.
I would say HKIAC makes contributions to international arbitration practice in three key ways. One is the promulgation of our procedure rules and the practice. We have published multiple sets of arbitration rules since we were established, and the main one is the 2018 HKIAC Elements Arbitration Rules. So many of those provisions were trend-setting provisions, and they have made a positive impact, I think, on the shaping of the international arbitration practice. And in addition to that, we also regularly introduce new initiatives, services such as our Tribunal Secretary Service, which has proven to be quite an effective tool to reduce costs and to help tribunal really focus on the substantive decision making. And also the governing law provision that we introduced into our model clause in 2014, in which we prompted the parties to consider designating a governing law of the arbitration agreement itself, where the law of the seat and the law of the underlying contract were different. And at the time, HKIAC was the first arbitral institution to introduce such provision in the model clause, and now this is an issue being discussed in the VISMA problem. So I think that's one way that we sort of make an impact on international arbitration practice. Another way is active participation in law reforms in and outside of Hong Kong. So we have, over the last years, we have worked very closely with the Department of Justice of Hong Kong to consider amendments to the Hong Kong arbitration ordinance. So for example, we have worked with the DOJ on the amendment to expressly recognize emergency arbitrator procedure and the enforceability of emergency arbitrator decisions issued in and outside of Hong Kong. And the second amendment was the arbitrability of IP rights, which clarifies that any disputes in relation to intellectual property rights can now be submitted to Hong Kong for arbitration, and it would not be contrary to the public policy of Hong Kong to enforce any arbitral law concerning IP right in Hong Kong. And the third and most recent amendment is third-party funding, which we provided very detailed submissions to the DOJ. And on 1st February this year, the amendment has finally come into force in full. Through the amendment, party can now use third-party funding to fund their claims in arbitration proceedings and any associated proceedings in Hong Kong, or any cost of services provided in Hong Kong in relation to arbitration proceedings seated outside of Hong Kong. And the third way is to facilitate collaboration with our partners and other interest groups in and outside of Hong Kong. We run a very extensive outreach program. So we organize a lot of events, initiatives in and outside of Hong Kong in partnership of local organizations to promote international best arbitration practice in those jurisdictions. So I would say these are the three key ways in which HKIAC makes a positive impact on the development of international arbitration.
Yeah, that's indeed great work, and it's really very important for the whole region. And that's great that HKIAC tries to be a kind of trendsetter in the sphere of arbitration. And I think another issue is that Hong Kong hosts very good, very large competition with East competition, moot court, and Russian teams are also participating in this competition. And I also had the honor to act as arbitrator in this competition. And I think it's very good for the new generation of arbitration practitioners that are coming. And I also know that you have HK. Young practitioners,
yeah, HK45.
HK45 initiative. So that's I think it's really very important. Moving to Russia, it's interesting to know why is HKIAC interested in Russia, and actually what is the relevance of HKIAC to the Russian market of legal services, in your opinion?
No, I think Russia is a very large market and economy with very dynamic legal and arbitration community. You have your own legal arbitration system here, but I think the community here has a strong interest in the practice outside of Russia, in what's going on in international arbitration affairs. So I think that provides a scope for HKIAC to come here to have a dialogue to facilitate communications between the community in Hong Kong and the community in Russia, to share knowledge and to share the Hong Kong practice. And there has also been a growing economic activity of Russian companies in Asia, particularly in China. In recent years, the Russian and the Chinese governments have signed a number of landmark bilateral agreements, mostly in the energy sector, but also in international trade as well. And many Russian companies are also now very active in other Asian countries as well. So I think that is an area where HKIAC can become very relevant. We are an international arbitration center with a particular experience in handling disputes involving Asian parties. So I think for those disputes, for those transactions between Russian companies and Asian companies, it will make sense for them to choose a venue that is close to the transaction, close to the center of the gravity of that economic activity in relation to those transactions. So I think Hong Kong HKIAC will be the very good option for those transactions and disputes.
Thank you, and I hope that Russian parties will more and more choose Hong Kong as the seat of arbitration. Well, arbitration is also is about arbitrators. So it's what we do, our work as arbitral institutions. We do it for the users, for the parties, and for the arbitrators, who are actually the main decision makers in arbitration. Can you please share your views why it is good for Russian parties to choose Hong Kong arbitration for any arbitration administered by any institution, and what Russian arbitration practitioners should do to promote themselves as maybe arbitrators and counsels in the Asia-Pacific region, and whether, in your opinion, this region is prospective for the young Russian practitioners, whether they shall apply for scholarship, for example, for LLM programs in the Asia-Pacific region?
Yeah. So I think in relation to the first question, Hong Kong arbitrators are known for their expertise and experience in dealing with disputes involving Chinese parties. And many of them are also fluent in multiple languages, including Chinese and English. And given Hong Kong's special status as the special administrative region of China with a separate legal system from that of mainland China, and I think it makes sense for Russian companies to consider Hong Kong arbitrators to decide their disputes when they're dealing with parties from mainland China or other Chinese territories. And in relation to industry sector, Hong Kong is traditionally strong in maritime disputes and construction disputes, and increasingly also financial, corporate, international trade disputes. So arbitrators in Hong Kong have built up a lot of expertise and experience in those areas. So I think that is something that I think international parties can also consider the appointment of a Hong Kong arbitrator for those types of disputes. In relation to the second questions, I think there are many ways for Russian practitioners and arbitrators to increase their visibility in the Asia-Pacific region. Now, I think one of the benefits of practicing international arbitration is that there are a lot of conferences, a lot of events, a lot of networking events, a lot of opportunities to get to know other people. Now, I think making the right connections with the right people is a very important way to promote yourself, to increase your profile.
For example, Hong Kong Arbitration Week that is arranged by HKIAC
yes, so that is our pinnacle event. So I think that is a great event for Russian practitioners and arbitrators to come to Hong Kong to participate and to get to know the community in Hong Kong, what's going on in Hong Kong and in the wider region, to bring the Russian expertise to Hong Kong as well. With the growing economic activity of Russian companies in Asia, and I'm sure that the experience and expertise that Russian lawyers have will be very relevant and very useful to the transactions and the companies in Asia as well. And finally, there are many programs that HKIAC in Hong Kong provide specifically for younger practitioners, students, and arbitrators. Now, you mentioned the HK45, and that is the young lawyer group within the HKIAC. It's very active, has been organizing a lot of fantastic events, not just in Hong Kong, but outside of Hong Kong. It runs an extensive committee that includes representatives from jurisdictions around the world. So I think that is a good group for younger Russian practitioners to try to participate. Now, the Vismo East in Hong Kong is another great event for students, younger practitioners to participate. HKIAC runs an internship program, and we already have had many Russian students and lawyers that have participated in this program. And another one I will mention is HKIAC's Tribunal Secretary Training Program that we started in 2016 and has been successfully running around the world. And is intended to train young lawyers to become qualified tribunal secretaries and further down the line to become an arbitrator in the future. So I think these are all very good programs and opportunities, I think, for young Russian lawyers to participate in Hong Kong and Asia.
That's really impressive. Thank you very much for your extensive answers. Thank you very much for coming. I wish you good luck at HKIAC and wish good luck to HKIAC. And I'm very much looking forward to seeing HKIAC representatives and colleagues from Hong Kong in May at the St. Petersburg International Legal Forum. Thank you very much.
Thank you.
Thank you.